Committee will go ahead and come to order. This is the House Judiciary Non-Civil Committee. We're here to consider 4 bills on the agenda today. We'll go ahead and start off with Representative Paul Battles' House Bill 871. And Representative Battles, if you want to... You can come on over here, so be comfortable. Yes, sir. I understand. If you could pull one of the tall ones to you.
Thank
Great.
you. 871 is actually a continuation or the advancement of the sundown date on Joshua's Law. The actual bill itself and all the funding of that has already been passed through on Chairman Powell's bill. And all I'm asking that the date be would be changed from June 30th of 2013 to 2018. And that's the only thing this bill does, is to extend that date.
Any questions for the author, Mr. Ramsey?
Just a motion at the appropriate time, Mr. Chairman.
Okay. Any questions for the author? Seeing none, I see no one signed up for it. Mr. Ramsey.
I move do pass House Bill 871. It's LC 390078.
Motion by Mr. Ramsey, do pass House Bill 871, LC 390078. Second by Mr. Coomer. Are there any amendments? Seeing none, any discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it, the motion is adopted.
Thank you, Mr. Chairman and committee.
That might be a new North American record, Mr. Battles. Thank you for bringing the bill. Now hopefully we'll fund it. How would that be? We've previously considered House Bill 954 by Representative McKillop. We've had 3 hearings on the bill. Mr. McKillop, I know, has a substitute that's in your folder, which is... Let me make sure I've got this right. LC 256037S. Is that right, Mr. McKillop?
Yes, it is, Mr.
Okay.
Chairman.
So, if members would just ensure that they have the proper substitute. LC 256037S. What I'm going to ask Mr. McKillop to do is to go ahead and speak to the changes in the substitute. I'm then going to ask members if they have any questions specifically on the changes in the substitute, since we've already been through the bill previously, and then we'll go from there. Mr. McKillop.
Thank you, Mr. Chairman. May it please the members of the committee. We have LC 256037S, which is a substitute to 954. First of all, I want to thank the members of the committee for the time that everyone's put in listening to this bill. I think we're well over 5 hours on different types of input, mine, physicians, as well as public input. There were a couple little changes to the bill, some suggested by legislative counsel, one suggested by a member, and then some things just to make sure that we're up to date on the nomenclature of the different departments in the state. I will go through these and then take questions as instructed by the chairman. On line 90, the definition of medical emergency. What we've done there, instead of defining medical emergency in this location and then again in the Woman's Right to Know Act, which sort of dovetails with this bill, we've gone ahead and changed the definition in the Woman's Right to Know Act so that the definition of medical emergency is consistent throughout Georgia law on this topic, and the actual definition is moved to Section 4, which begins at line 145. And so it's the same definition that we had before. We've just moved it to a different code section in the code and referenced it there at line 90. No material changes, just moving things around to make it flow better. On line 62, we changed "the" to "an," that is, preserve the life of an unborn child, to make that clear. And then on line 110, we we had originally referenced this to the Department of Community Health because that in the code was who was administering the Woman's Right to Know Act. But it turns out through the different moving around of departments and renaming things, it is the Department of Public Health. So we were able to just strike the language that said Community Health and leave it with the department, because that is who is currently administering this act and the reporting requirements. Those are the only changes. No substantive changes, just moving things around and changed "and" to the to "and."
Any questions for the author on the changes in the substitute? Mr. Coomer?
Yes, just on that change at 110, does this reporting requirement in 110, is that the reason that you've removed the reporting requirements in lines 77 through 80?
That is not a change to the sub. That was in the original bill, and yes, all of the reporting requirements are administered through the Woman's Right to Know Act in already.
Okay.
And so what we've done is created the new code section at 110, 31-9B3, 31-9B-3, simply says put a couple more lines into the report that you're already doing. That is where we say that they will do this in conjunction with the reports already required under 31-9A6.
Okay, thank you.
See no further questions. What's the pleasure of the committee? Mr. Setzler?
Mr. Chairman, I'd like to make a motion, move to pass HB 954 by committee substitute.
Second.
Mr. Setzler moves do pass HB 954 by substitute LC 256037S, second by Mr. Hatfield. Are there any amendments? Ms. Abrams.
Thank you. I do have an amendment that I would like to pass around. A copy has been given to the author. And just to explain the genesis of the amendment, although there has been testimony in this committee regarding gestational age and the likelihood of fetal pain at the
Let me ask you to hold for 1 second, because we don't have enough copies,
Okay.
so let's just take a
Certainly.
brief time out and make sure everybody has a copy.
Can someone give a copy to Jill?
Does everybody have a copy? Ms. Abrams.
Thank you, Mr. Chairman. So as I was saying, following the intent of the bill and from the testimony that's been presented over the last 3 hearings, there has been a great deal of attention paid to 20 weeks. And I think that it's important for us to contextualize that in Georgia there are 39 counties that do not have OBGYNs, which requires that any woman seeking any of the seeking a study of a fetal anomaly or simply to have that 20-week checkup may have to go past the 20th week in order to just get access to a doctor. That many of the tests that are required, for example, if you have amniocentesis, that can take up to 2 weeks to process. And so even at the 20th week, when this tests are usually prescribed, the 18th or 20th week, it can be up till the 22nd or 24th week before these tests can actually have results. And we are requiring a fairly substantial and significant decision-making process that may not have medically relevant information available. Moreover, if the study that's been referenced to set 20 weeks is actually an 18-year-old study, and in 2010 there was a longitudinal study done by the Royal College of Obstetricians and Gynecologists that suggests that at minimum the age at which, the gestational age at which fetal pain may be relevant is 24 weeks, which would dovetail, I think, appropriately with the timing of the tests that are offered, the timing of the results that can be provided, and also provide a mother and a family with time to make determinations. So what we would ask is that this bill be amended to make 3 substantial changes. First and foremost, to change the probable gestational age to 24 weeks, which is, we believe, very consistent with the medically available information in the state of Georgia. When you have such substantial timetables and you're making such a critical decision, we believe 24 weeks is the more appropriate standard. Secondly, the question of medically fetal pregnancy is, we think, a critical issue. Earlier in this process, I asked the question about fetal pain, and the fact is that if fetal pain begins at 24 weeks, often the anisolephet, I'm mispronouncing the word, but those chromosomal abnormalities and those issues, they will not be diagnosed until after the 20th week. And certainly if pain is felt at the 24th week, without creating the opportunity for medically fetal pregnancies to be removed, you do actually condemn a fetus who is capable of feeling pain at 24 weeks to torture from the 24th week until actual gestation ends. And so we believe that if the intent is to prevent fetal pain, it is critical that we allow for medically fetal pregnancies to be defined as not only that case, making sure that if there's no heartbeat for the unborn child, if the fetus is anencefalitic, or if the diagnosis of a congenital chromosomal anomaly is incompatible with life, meaning that even upon delivery, the child will likely die in a short period of time, that we not require either a mother to carry a fetus to term that has no hope of life, but also that we don't condemn a fetus that has no hope of life after after gestation to essentially writhe in agony from the 24th week until such time as gestation occurs. And so I would ask for this committee to consider this amendment. You'll notice that the language at the top says substitute to 954 by inserting, because I don't know exactly where this would go into the bill. I would ask that if it is favorably considered, that we work with Ms. Travis to figure out where in the bill it could be adopted.
Fair enough. Mr. McKelvey, you want to respond to that at all?
Oh yeah, I would just say that the fact is that in Georgia, 7 years ago, we adopted the Woman's Right to Know Act. It has already codified in those findings that fetuses can experience pain at 20 weeks of gestation. In fact, it's in the handbook that we hand out from the originally from the DHR, now from the Department of Public Health, but it's in every single handbook that we hand out under these circumstances, that by 20 weeks gestation, the unborn child has the physical structures necessary to experience pain. There is evidence that by 20 weeks gestation, unborn children evade certain stimuli in a manner in which an infant or adult would be interpreted to be a response to pain. Anesthesia is routinely administered to unborn children who are 20 weeks gestational age or older who undergo prenatal surgery. So this has been the law. The 20 weeks has been the law in Georgia for 7 years. It is the compelling state interest which we are articulating in Georgia to demonstrate the right of the state to prohibit abortions after the 20th week. And so while I can appreciate Representative Abrams' arguments. 20 weeks has been the law in Georgia for 7 years now. It is the compelling state interest, and I would disagree. I'm not a doctor. I heard the same testimony. I've researched it myself. I would disagree. I believe that all of the anomalies can be determined at an earlier time that is being represented, and so I think 20 weeks from fertilization, which, let's remember, 20 weeks from fertilization is 22 weeks in the way most people think about and measure the time period, is a sufficient length of time. The last point would be that the standard of care, I think that hopefully when we pass this law, the standard of care in Georgia simply means the standard of payment. That is, when an insurance company will allow payment for the tests that are being conducted when you have a pregnancy that would indicate those tests. And so when we pass this, I believe that they'll simply say, we're just going to go ahead with those tests 2 weeks earlier. They are effective at that point, and those concerns will be responded to in that way. I would ask that the committee not entertain this amendment and pass the substitute as presented.
Just to be clear, the first thing you said regarding the fetal pain in 20 weeks, that is contained in current state government literature from, I guess it was DCH, now it's
Department of Public Health, and it's codified in 319A4.
Okay.
Mr. Chairman, if I might,
Sure.
What I would respond respectfully that this body often takes up information when new information is available. The study that I'm referencing was not available in 2007. It wasn't available 7 years ago. It was published by the Royal Academy in 2010. It does a longitudinal study of all the information, including the studies that Mr. McKillop references, and that longitudinal study demonstrates that actually 20 weeks is too early, that it is more relevant and more likely to be 24 weeks. And that this body has often updated its code to recognize changes in the law and changes in science. And indeed, we just passed a bill brought by Mr. Dungeon recognizing that electronic devices, which have been prohibited in our classrooms for the last 100 years in Georgia, or at least the last 50 years, that we needed to change that because those same devices are now useful for delivering education. So we do recognize new science, we do recognize new information, and indeed it's the responsibility of a living, breathing body of legislators to take into consideration updated information and to make changes accordingly. My concern, putting aside my objection to the underlying notion, my point in offering this amendment is to recognize that we are about to condemn women to a certain torment because we do not provide as a state adequate health facilities in 39 counties where these gestational anomalies can be identified. They are limited where they can get the information, how they can access the medical attention that they need, and that when there is no heartbeat of an unborn child, if a child is forced to, if we do accept as a premise fetal pain as the legitimate issue, I fail to see why 24 weeks doesn't adequately capture both the protection of the mother and the family, but also meet the goals of the author. I believe I've demonstrated in this committee that even when I deeply disagree with the fundamental premise of a bill, my goal is usually and almost always to deliver the best possible law. And I think the best possible law in this case recognizes that 20 weeks is no longer good science, that 20 weeks has been dismissed as legitimate science, and that we need to look at the legitimacy of protecting not only the fetus, but also the mother who's responsible for carrying that fetus, and that this bill be designed in such a way that a medically futile pregnancy, which is not determined by any individual here, but is determined by a medical doctor, that we provide that protection. And to his point about the fact that our laws currently recognize 20 weeks, our law also recognizes the ability of 3 doctors to say that a pregnancy is medically futile and to take action. We are fundamentally changing the nature of how our law operates, and thus I think we have to accommodate the implications of the changes in that law, and I would ask for favorable consideration of this bill, of this amendment.
Thank you. The question occurs on the amendment offered by Ms. Abrams, AM 331155. All in favor of the gentlelady's amendment signify by raising your hand. Opposed? And the amendment fails. Are there any further amendments?
Yes, I have a further
Ms.
amendment.
Abrams.
This is a specific amendment to the existing language, lines 13, 15, 4, 53, 117, 124, that where the word 20 weeks appears, that it be stricken and replaced with 24 weeks.
Okay. I'll just summarize it by saying wherever in the bill it references 20 weeks, to strike 20 and insert 24. All in favor of the gentlelady's amendment signify by raising your hand. Opposed? And the amendment fails. Are there any further amendments? Ms. Neal.
Thank you, Mr. Chairman. My amendment is in reference to line 52. After the word unless, I would like to add the following: the pregnancy is the result of rape or incest, and just completing the sentence and continuing on, and following on with the current language that's in the bill.
Would you repeat that for us?
Line 52 after the word unless.
I have line 50. I think you mean line 53.
Where am I? Hold on, I gotta look at it. Yes, line
Okay.
53 after the word unless, adding the pregnancy is a result of rape or incest, and then following on with the current language that's already in the bill. My concern here is that the bill doesn't address rape or incest. Aside from any argument, I feel that either way, I think that's appropriate when it comes to women that are victims of any type of crime, whether it's domestic or otherwise, or any type of victim of violence. I think it's only appropriate that we at least address rape or incest in this manner.
Okay. Is any member of the committee unclear on the amendment on line 53? Seeing none, all in favor of the gentlelady's amendment signify by raising your hand. Opposed? And the amendment fails. Are there any further amendments? Seeing none, we have a motion of due pass by substitute LC 256037S and a second. All in favor of the gentleman's motion? I'll recognize you for that. Ms. Abrams moves to table further consideration of HB 954. All in favor of the gentlelady's motion signify by raising your hand. Opposed? And the motion fails. We have a motion. We have a move. We have a due pass move and a second on HB 954 by substitute LC 256037S. All in favor of the gentleman's motion signify by raising your hand. Opposed? And the motion's adopted. Thank you, Mr. Miller. Thank you, Mr. McKillop. Let's go ahead and call House Bill 1114, Representative Setzler. Oh, I'm sorry. Do we have the substitute ready on that? Okay. Okay. Yeah. Yeah. We're going to go ahead and postpone consideration of 1114. We have the sub came in late. Mr. Pack, let's go ahead and go to House Bill 940. And then we'll take up 1114 after that.
Thank you, Mr. Chairman and members of the committee.
We're looking at substitute LC 256035S?
Yes, sir.
Okay. LC 256035S on House Bill 940.
Members of the committee, I bring before you for favorable consideration committee substitute HB 940 and reflecting the number that Mr. Chairman just read. This bill is a relatively simple bill with an important goal in mind. As you're well aware that properly funding the Capital Defender Program and the Indigent Defense Program is a high priority of the committee, high priority of all members of government. And to that end, anything that might add to making sure that the system is operating in an efficient manner, I believe is very important. Matter of fact, I just read an article today regarding a Gwinnett County case, and the Supreme Court has just notified that the undue delay caused by insufficient funding of capital defense may run into some speedy trial and some constitutional problems, so this is an important issue. I bring before you a bill to amend and add one sentence to Section 17-12-12.1, and the operative language only concerns lines 31 through 33. Basically, currently, if you have a defense attorney appointed pursuant to a conflict, so for example, if a government employee cannot represent that person because of conflict, you procure someone else that's not in the government system, a private attorney, to handle that litigation. And that fee, in cases where it's a high-profile case that takes a complicated case, the fee is actually split amongst who bears the burden of cost. For cases that exceed $125,000, 25% of it is borne by state appropriations, 75% of it, and then remaining 25 is actually borne by the local government in the county. If it's over $250,000, it goes to actually 50-50. But the way the invoicing currently is structured right now, there's really no checks and balances until the invoices are the expenses are expended and invoices are submitted to the Capital Defender's Office with respect to the payment. And there's big litigation over that, and then you go in front of the judge, and the judge kind of hashes it out. And you saw this kind of profound effect occur in the Brian Nichols case back in 2005. There was fights going back and forth about appropriateness of fees. There's a judicial intervention, and of course there were several, Rule 9 sides for contempt for failure to fund, and this is really going to come to head soon. This bill actually adds one more provision to try to head off that fight and try to make sure that there's some judicial review of the invoices and expenses in cases like that, that before the council is required to pay the invoice, we're requiring that the contractor or the defense attorney submit the invoice for approval to a judge. Practically speaking, the judge is going to be, who's assigned to the case, can be familiar with the facts of the case, could make a better determination whether or not it's a reasonable and appropriate expenditure, versus, this is how the way system's done in the federal system, where the judge actually has reviewed the invoices before approving for payment. The better practice going forward will be any person who's appointed will submit a budget, and I actually had a conversation with some of the defense lawyers in the federal system. They actually submit a budget to make sure that they're within some expectation. If there's some deviation to that, you actually go ahead and explain why you need a deviation. But this bill does not require submission of budget. It just requires that before payment of the invoice that you do get judicial sign-off on that. I've worked with the initial bill, had some language issues that I think Travis Sarkison had, and I've worked with him, and he just let me know that he has absolutely no issues with the current community substitute. So I think any issues that the Conflict Defender Council, the director had, has been resolved. And with that, I'll be free to answer any questions.
Vice Chair.
Thank you, Mr. Chairman. Basically, you're setting up a system whereby any conflict defender, or I guess any defender that's receiving state funds, would have to go through getting an approval from the presiding judge in order to get paid. Is that correct?
I think it's in the contractual provision, so it's not actually a state employee, but someone who's appointed because of a conflict issue.
Conflict,
yes.
Okay.
Right.
It occurs to me that may not be a good idea, and I say for a couple of reasons. One, when you compare it to the federal system, federal judges are appointed for life, and they don't have to stand for election or re-election, whereas the Superior Court judges are elected. And what I fear about putting a provision like this in place is that a judge who may feel some political pressure not to approve an attorney's fee bill that might otherwise be proper, but might be sizable because of the amount of work done, that judge may feel some political pressure not to sign off on that. And you're basically, you have no escape hatch here if you've got a recalcitrant judge. And don't say it can't happen, because it's happened to me on more than one occasion. And I understand that there have been a lot of conflict cases that around the state during the period of transition where there were conflict attorneys that were appointed, and those people have never been paid. Now, I've got some problems with putting any further obstacles in place that would cause defense attorneys who are doing their jobs not to be paid appropriately. I understand.
Okay. Ms. Abdul Salam.
Thank you, Mr. Chairman. Representative Pack, following up, I guess, a little bit on what Representative Hatfield addressed, what would the scenario look like if the parties did not realize that there was conflict until later in the proceedings? Would they be able to then go back and enter into a contract with the neutral, hopefully a neutral attorney at that point?
I think that I think that situation does happen, and for one reason or another. Depending on if there is a witness who provides additional information relevant to the case, but I'm not too familiar exactly how that would be handled, other than the fact that you have to determine whether or not conflict is something that's waivable. If not, I believe you have to appoint a brand new attorney that's independent from that, from the case. Of course, this bill doesn't have anything to do with whether or not an ethical standard should be applied to that. All this says is related to any invoices for that particular person appointed before being paid, they should be submitted to the judge.
And in the instance where the judge may be the person with the conflict?
Well, I believe judges kind of govern their own conflict and recusal issues, and this happens from time to time as well, and the judge has to recuse him or herself from ruling on it, which will certainly, whoever's presiding over the judge would be the one determining the propriety of the invoice. And
final question, if this is able to be passed and implemented, would that help in any way to kind of deal with the backlog of cases by having this available?
I don't necessarily think it will have a removing of the backlog. That certainly proper funding is one of the probably causes of the backlog. But this bill does add in an additional kind of layer of protection, to which that the invoices might not be it would be subject to reasonableness, someone who's actually familiar with overseeing the case. So in keeping the cost management issue and the overall system and the funding, I think in long term it may actually help to properly fund and move cases along.
Okay. Thank you so much.
Thank you, Mr. Chairman. Mr. Pack, in reading the bill and hearing you describe it, it seemed that the intent was to make this requirement apply only to those cases where the fees are over $150,000 or over $250,000. Is that correct? I'm asking because that's kind of what I picked up on in the discussion, but the language doesn't say that. The language says the council should pay. It makes it broader than that. It makes it, in my opinion, would make it apply to any invoice for services.
That's right. If that's what you understood, that's incorrect. I pointed out the costs, because the county certainly has, if it exceeds a certain amount, the county starts having a vested interest in making sure. But no county employee is actually having input on whether or not something is appropriate or not. So the reasoning behind it, my explanation is related to the reasoning, not necessarily to say that it only kicks in at a certain amount. Thank you for pointing that clarification out.
So the answer is then that this provision would apply in any, it would apply for any situation where an attorney is seeking payment from the council.
In capital defender cases, yes.
Only in capital defender cases. Okay, thank you.
Any further questions for the author? Seeing none, Judge Quillian Baldwin from LaGrange is here. Judge Baldwin, it's great to have you. For those who don't know, Judge Baldwin used to be State Senator Baldwin. Would you like to come forward, Judge? We're happy to have you.
On behalf of the Council of Superior Court Judges, we just want to say a couple of things about this. Some of them agree with Judge Hatfield. I mean,
Could you, Judge, could you move the microphone closer to you? Thank you.
Representative Hatfield on what he said. Some of the judges do. I think we're not sure what problem this bill is really going to solve. But if y'all direct us to do this, we will certainly do it. I do need to point out, and I think this committee primarily is probably made up of lawyers. I don't know all of you, but you know, when you start talking about a death penalty case and what it takes to handle one of those cases, you're talking about a tremendous amount of time. And every lawyer is different. Every lawyer looks at a case differently. And some lawyers might spend X amount of time and another lawyer spend Y amount of time. It's hard to tell. If y'all ask us to do this, we would like for there to be some kind of requirement that they give us an interim bill all through the process, instead of getting a bill at the end and then having to go all the way back through everything and try to figure out what this person did and whether it was valid or not. Somebody asked a question, said something about us approving the expenditures before they got there. I think this is just approval of the final bill is really what it gets down to. That's going to be a lot of stuff to look at, and it's hard to question if they have a contract and their contract says they're to get $500 an hour and they've showed they have worked X amount of hours. You know, it's going to be hard for us to say whether they worked that X amount of hours or not. So, you know, what I'm trying to say is, if y'all direct us to do this, we're going to do it. But I also want you to understand that it's not going to be an easy thing to sit there and say, if somebody's met the requirements of their contract, that they shouldn't have the bill approved. So we just want to point out those problems. I will, though, also say that we don't have this situation really come up a lot. I've been a judge over 16 years, and I hadn't had but 2 death penalty cases the whole time I've been a judge, and neither one of them had the conflict problem. So I just those are just some comments that I think you need to think about before you pass this bill. Okay? Anybody have any questions that they'd like to ask me?
Thank you, Judge.
Thank you for letting me speak.
Yes, sir. Anytime. Thank you for being here and lending your perspective. I see no one else signed up to speak on 940. What is the will of the committee? Mr. Ramsey.
Well, I'm inclined to make a motion do pass, but I want to defer to the author. There's some language things we want to work on between now and another hearing. I don't think this is a motion, but I'd offer the committee to postpone consideration to the next committee hearing. I'd like to hear from the author on that point.
Mr. Pack, you can address that now, or if you want to reserve the right to carry it over to Wednesday, you can too. First out of the gate, I'm going to leave it to you, how you want to handle it.
In light of the judge's testimony, I'd be happy to try to work to address some of his concern, and I request that we postpone action on the bill until Wednesday.
And we will do exactly that then. Bear with me for one moment. On House Bill 1114, I know there's some late drafting going on right now, so and council has left the room to go ahead and do that. What we'll do in order to afford the possibility of acting on that bill is that we'll stand at ease. We'll stand at ease until 2:15, when we'll have consideration of House Bill 1114, 2:15 p.m. All right, thank you all for your patience. We'll go ahead and reconvene or continue our meeting. We'll go ahead and take up House Bill 1114, Representative Setzler.
Thank you, Mr. Chairman, members of the committee.
The power of the mute button.
I understand Representative Hatfield's taking a foray into tax law this tax season. I guess the billings have been down the last
April
couple
15th
months.
looms large.
Thank you, Mr. Chairman, members of the committee. I bring before you today House Bill 1113. I'm sorry. Bring before you today House Bill 1114. We've got going to be offering a substitute based on what was worked on by the Ramsey subcommittee and some subsequent changes that have been brought to us by our friends from a number of the affected healthcare institutions. We'll be working off of LC version 295206S. Mr. Chairman, if it pleases the committee, I'd like to provide kind of a flyover of the bill, the intent of the bill. I'll walk through in some level of detail the way the bill is constructed, and if there's some testimony, I'd like to certainly, at the will of the committee, allow folks to testify on behalf of this. There is quite a bit of relevance, I would argue, to 1114. The issue of assisted suicide has been before us as a nation for the last 20 or more years. Some states have actually acted to authorize and allow physicians to assist folks in killing themselves. But I think it's consistent with the norms and the expectations of the people of Georgia that purposely helping someone kill themselves, as we'll find through very deliberate means of either physicians or non-physicians, is something that's not consistent with the charge I think we as members of the Georgia General Assembly were sent down here to represent. So having said that, HB 1114 recognizes that in early February of this year, there's a case that came before the Georgia Supreme Court that although many who were advocates on behalf of sanctity of life issues recognized for years the 1993-1994 law that ostensibly addressed assisted suicide was a very weak law. In just early February of this year, it was recognized by the Supreme Court in a 9-0 decision striking down that law as in some areas being unconstitutionally vague and in other areas, frankly, being nothing more than a restriction on First Amendment speech. That any vestige of an assisted suicide law we had in Georgia was not constitutionally valid. And frankly, laying, I believe, at the feet of this legislature the question of how we would address the issue of assisted suicide in Georgia. I'll have counsel, who is plaintiff's counsel in that case, who can speak to that in more detail here in a moment, but specifically to 1114, the bill simply addresses the issue of individuals who have actual knowledge that a person intends to commit suicide, who then willingly and knowingly assist such person in the commission of that suicide, shall be guilty of a felony, punishable by 1 to 10 years in prison. Again, consistent with other homicide offenses in Georgia, 1 to 10 is largely consistent with how this is addressed in many other states. As you know, more than 30 states have assisted suicide statutes on the books, and the work that's before the committee today is a product in large part of some of the language from those statutes, and also in large part from recommendations from members of the medical community and both at the Hospital Association, folks that are involved in various counseling and in terminal care settings, and we'll walk through the way that their concerns have been addressed in comparison to what was offered in subcommittee. Page 2 of the bill, again, page 1 really just addresses that, again, that criminal penalty. One thing it does do, however, before we get further into the bill, it does recognize, and this is a change since subcommittee, the term assist means the act of physically helping or physically providing the means. We wanted to be abundantly clear that the physical act was what this statute intends to address. There was some concern that if we didn't speak to physical assistance, that a website that could be talking about how you kill yourself or talk about different methods of death could, by a passive action of a person opening a website and speaking to some of these things, could be implicated in this, in that it helped effectuate and provide the means to a death. We wanted to make sure that a physical act was an important predicate in the offense we're creating here. Page 2 of the bill, lines 26 through 36. All the language that's needed is in there. However, I would ask members to take a look at an amendment that Ms. Bazemore has passed around, an amendment that's been crafted by Ms. Travis within the last hour, at my request, to make it what I call Setzler-proof. The language in 26 through 36 is legally sufficient, but I was concerned it was a little vague in the way the ors and the semicolons, the references were made, and Ms. Travis has kindly helped us make this very clear. What you see here in an amendment I will ask the committee to consider would be a substitute for paragraph C, or subsection C, that I think would just further clarify the existing language that's before you in the 5206S substitute. If you could take this sheet, though, I'd like to walk through this so we can speak to the various elements. What subsection C does is it talks about those actions which this statute, this criminal statute, does not apply to. As you know, although this intends to address the behavior of groups such as the Final Exit Network, whose business it is to help folks physically kill themselves, provide the physical means. In many cases, or in some specific cases, by taking a bag, helping a person who wants to die, put a bag over their head, pumping helium into the bag, and killing them by helium asphyxiation. That intentional act is being done in our country. It's being done. Those acts similar to that are being done in the states where assisted suicide is specifically legal. And because this subject matter deals with issues of people with, in many cases, with chronic medical conditions or receiving legitimate end-of-life care, we've tried to very, very carefully select this language to allow those things that are otherwise legitimate, legal, existing medical procedures. We want to ensure those procedures are not unintentionally covered in this bill, but that the actions of those whose intention, whose mens rea is to help effectuate the death of another person, is covered, consistent with the purpose of the statute. Mr. Chairman, I can walk through section C to kind of speak to what's in and what's out, if it pleases the committee, before we move further into the bill. Would you like me to proceed that way, Mr. Chairman?
The question I had to do with, and I remember section C. Bear with me for one moment. And I think this had to do with what I'll call lines 27 to 30, but that was in the original bill.
Right.
And now I know we had the substitute and now a new substitute, as well as an amendment.
All those issues are in this amendment. I'll walk you through that. And again,
as it relates to narrowing to a medical professional?
Indeed.
Okay. If you could walk us through that, that would be great.
Okay.
Mr. Chairman?
Yep.
The copy that we have for the amendment is the one with the blackout?
Yeah, that's my understanding.
The redacted line, yes.
Okay.
And again, to be clear, although the language is consistent with lines 26 through 36 of the substitute that's before you, I believe this to be a more clear presentation of that's easier to follow. I think would be easier to for laymen to follow and understand the statute as well as learned attorneys. So if you can look at, again, what is represented in lines 26 through 36, if we can look at the proposed amendment that I'll ask Chairman Hatfield to offer here in a moment. The activities that will not be considered assisted suicide will be any person prescribing, dispensing, administering, discontinuing, withholding, or withdrawing medications or medical procedures or advocacy, when such actions or advocacy is calculated or intended to relieve or prevent such person's pain or discomfort, but is not calculated or intended to cause such person's death, even if the medication, medical procedure, or advocacy may hasten or increase the risk of death. Let me explain. From prescribing, dispensing, that whole list of items, those are the things that are administered to people, again, frequently in end-of-care settings that we recognize are legitimate, is the legitimate provision of medical care. Furthermore, the withdrawing of medication or medical procedures, whether it's taking someone off of a respirator, taking someone off of a medication, or some kind of electronic device that's keeping their heart beating, those kinds of the withholding of those procedures consistent with an individual's desires, or as we'll see down in paragraph 2, advanced directives, those are legitimate medical procedures that we don't want to unintentionally get caught up in this definition of assisted suicide. Furthermore, advocacy. In our subcommittee hearing, a learned member of the advocates community came in and said, hey, they're professional advocates, they're family advocates that advocate on behalf of the patient's will. In many cases, patients want to, they may want to act against a doctor's recommendations. If the patient says, you know what, I don't want to stay on the respirator, or I don't want to eat only the things that you're giving me. I want to eat other things, or I don't want to not smoke. You know, if a person decides they want to smoke against the doctor's orders in their last weeks of life, or in a serious medical condition, that someone that advocates on their behalf. Hey, listen, Grandma wants to smoke. You should let her smoke. You recognize she's lucid. She's not making. She's able to make decisions for herself. You know, physician, hospital, hospice. There are people whose jobs it is to advocate on their behalf, and we want to make sure that advocacy, even if it is advocating on behalf of someone's wishes that may not be helpful to their long-term health, or it might even hasten their death. If perhaps smoking 2 packs a day for the last month of their life might hasten their death. But the idea of pure advocacy that's not intended to bring about someone's death should still be covered under this exclusion for those things which are not assisted suicide. We're very careful to make sure that general advocacy is not unintentionally caught up in this.
Let me ask you a question, if I could, just following up on that, and I may have just missed it. Any person prescribing, dispensing, administering, that would strike me as perhaps opening the door to, I mean, it's a fine line between, and we've discussed this previously, it's a fine line between someone who is claiming to go ahead and take action intended to go ahead and relieve pain as opposed to cause death, but it just happened to cause death. And erring on the side of caution, I mean, that's very much a judgment call on. It could just be a matter of keeping a straight face, because how you get into a courtroom on that unless you've got somebody saying that someone said to me that, well, I'm going to give him this medication under the guise of relieving pain, but really that's not the case.
Mr. Chairman, you've hit on the sensitivity of this very issue. The operative clause in this entire exemption, which is so important, is the language, but is not calculated or intended to cause such person's death. To get a criminal prosecution on this, I believe a prosecutor, or in a civil case, I think that the civil suit will center on one's calculation or intention to cause a person's death. I don't think there's any way to get around that. When you get into the way this works, there are people in legitimate clinicians, be they or pharmacists who dispense drugs, clinicians who order drugs, nurses, RNs, LPNs, physicians who are involved in this continuum of care, in many cases very, very high cost, high sensitivity end of life care, that are dealing with multiple conditions. You could have a person whose liver's giving out, and the person decides they want to stop their dialysis process. That's going to hasten their death.
Sure.
So very often morphine and different pain interventions.
I don't dispute any of that. I guess my question is more toward you're mentioning these scenarios that involve medical professionals. Why not put wording in here? And of course, we're seeing this right now, and I'm not faulting that. That's the process. But all the scenarios you've spoken of just now all go to the conduct of medical professionals, which I agree with.
Sure.
Why not go ahead and confine that paragraph to any provider? I mean, whatever the nomenclature is, but any medical provider.
In that case, you've got somebody who's perhaps administering a drug, for example. Let's say there's a prescription drug that a family member that's not a licensed medical professional is administering. There could be a family member who's providing advocacy on behalf.
Okay.
We want that to be broad. I don't think that not further limiting that solves the problem, because it's really going to hinge on the intention of causing a person's death, Mr. Chairman.
But do you see my, and if not, just tell me, but I mean, do you see those, I can see those scenarios, and part of our job is to identify those scenarios ahead of time, you can see those very close calls about what was the intent at that time. And of course, that's just going to be Judge McCall, and obviously that's a question for the jury.
Yes.
And
Mr. Chairman, our concern is that
but it may not be foolproof, and I understand.
This umbrella, as it were, of who this does not apply to, we would rather err on the side of broadness on who this does not apply to, rather than get folks caught up in this who are performing legitimate functions who this does apply to.
Okay. So good dialogue. Ms. Byrd.
Thank you, Representative Sessler. I need to be clear about what you're just talking about. My mother thoroughly enjoyed smoking, and she was on her deathbed, and we did have hospice, and so I chose to let her smoke. So how does that happen? What happens with this?
That's precisely what we're trying to allow to have happen. The sense of advocacy, you could have had, your mother's doctor might have said, what was your mom's name? Bev. Bev does not need to smoke. This is going to kill her. It's going to hasten her death. He could lay out all these reasons why, and he could, and frankly, his medical standard of care could require him to oppose doing that. But this advocacy piece is intended for you to say, doctor, it's her desire to smoke. She wants to continue to smoke, and if you advocate on her behalf, even if you were to go around the doctor to perhaps a higher level in a hospital or a medical facility to say, you know what, she's got a right to smoke. I want her to continue to smoke. It's what she wants. It would allow you to do that without getting caught up in this definition of assisted suicide. If the action of her smoking or the action of her drinking led to her death being accelerated, that you couldn't be implicated as an advocate on behalf of her smoking or drinking or bad habits, even though it was against doctor's orders, and it might have hastened her death. We're very clear to make sure precisely that kind of action is not caught up in assisted suicide.
Follow up?
Sure.
So, all right, now she's in hospice, and she's on medication to relieve the pain, and then I make the decision to over-medicate her. What happens?
If she's in a situation of significant pain, and as we know, that's very sadly the case much of the time. If the doctor prescribed 50 milligrams of something to ease her pain, and you said, you know what, I want you to turn her up to 75, I think she's in more pain than you think, you'd be covered here, unless your decision to give her 75 can be linked to an intention to kill your mom. Then your advocacy for, hey, let's pump up her morphine to a higher level, it falls under advocacy, and that's specifically why that's here. That kind of advocacy we didn't want to have caught up in the assisted suicide definition. Now, again, if someone recognized that you were trying to kill your mom and you were recommending a lethal dose, then again, and could prove that intention on your behalf, then that'd be a different story. But they'd have to prove your intention of upping that dose to cause your death and the physical act of doing things. We believed in the existing bill without this word advocacy. We believed advocacy was covered, but we added out of an abundance of caution to make sure that kind of behavior is specifically spoken to and protected.
Mr. Pack.
Thank you, Mr. Chairman. Representative Setzler, a practical question on line 37. 38, and also I think it relates to language saying that a healthcare provider who's convicted, they have to kind of self-report themselves. And similar to, I guess, down here in lines 56 through 60, what happens if they don't? Because I mean, I can imagine a situation they get convicted of a crime. I mean, their concern is not saving their license, but keeping them out of prison. So if they don't self-report their conviction, what happens?
I had that same question when we drafted this. It's my understanding this is consistent with how statutes, a self-reporting responsibility for physicians exist in other parts of the code. I would defer to counsel for perhaps a little bit more direction on that. Our intention here in 37 through 43 is that if someone is convicted and all appeals are exhausted and they're duly convicted of assisted suicide, they lose their license. That not be left up to the board. You'll see down in the civil setting below, if they're found civilly responsible, then it's up to the board to make a determination of what happens with licensure. But if they're convicted, they lose their license, definitively. I would ask counsel with respect to the self-reporting. I think she's digging that out for us.
While I'm just looking, can I have a follow-up,
Sure.
Mr. Chairman? On Section 2, it looks like you're creating a new tort. Am I correct in assuming that?
No, sir. The original bill that was filed initially, the version that went in the internet when bill was initially filed, changed the wrongful death statute based on some, I think, very legitimate concerns about if you had family members who were complicit with this under the current wrongful death statute. If a spouse, for example, were complicit with the suicide, they have sole standing to bring a wrongful death case. And if that person refused to bring a suit, they could sign a release at a very low level, a release for $10, or could refuse to bring suit, thereby stymieing another suit. So we had tried to address that in the base bill.
Mm-hmm.
We recognized that creating that new tort structure was problematic, very problematic to the medical community, and recognized that the juice wasn't worth the squeeze, as it were. And that there'd be a way, using our existing statutes, I think provides the adequate civil remedy. So all we do here in Section 2 is provide a provision for attorney's fees and a provision for that deals with licensure action if there's a civil judgment.
So who do you envision bringing a suit if a spouse was complicit? Because in line 49 says a plaintiff who prevails. Does any relative have standing to sue, or
no? Under our current wrongful, all this does is it taps into 5144, which is our existing wrongful death framework. Our current pecking order in law is if a married person is a victim of wrongful death, then their spouse has sole standing. If their spouse passes away or they don't have a spouse, then it goes to kids, and there's a case law lays out a structure there. But as it stands today, if it's a married person, the spouse has they solely have the bite of the apple. And frankly, as we move this bill through subcommittee, we recognized we don't need to be rewriting wrongful death code. We want to leave the status quo as it is, and that the existing wrongful death structure was adequate for a civil remedy.
Mr. Coomer.
Thank you, Mr. Chairman. In keeping in the same vein of discussion, at lines 50 through 52, the language is a prevailing respondent may be awarded reasonable attorney's fees and expenses of litigation only upon a showing that the action was frivolous as set forth in Code Section 9-15-14. I think I understand the goal there, but my concern is that this language probably has an unintentional limiting effect in that if you look at 9-15-14, a defense or an action being substantially frivolous is only one of several reasons for which a court may award attorney's fees pursuant to 9-15-14. I was wondering if you would be open to, well, first of all, I'll also say, if you didn't have that language, if you didn't have that sentence in there at all, 9-15-14 would still apply. And so I'm wondering if you'd be open to either eliminating that sentence entirely, or otherwise amending it so that you take out this reference to only upon a showing that the action was frivolous as set forth, and replacing that with language, for example, that says after the word litigation, if authorized by Code Section 915.14. I know that's two questions in one.
Representative Coomer, I appreciate the concern. We're trying to set an attorney's fees structure in this that we think's most workable, and that's consistent with how attorney's fees ought to flow in these kinds of cases. My counsel, who helped early on in the crafting of the bill, before we engaged the medical community, before we engaged the Attorney General's office, who was frankly the plaintiff's attorney in the Georgia v. Final Exit Network case, can help craft that, and I'd prefer to defer to him as a practitioner. So if we could address that in a moment when he's up speaking.
Let's have him come up now. No time like the present.
Yeah, and
go ahead and speak to that.
Sorry.
And with the author, because I wonder what the intent is. Is the intent to limit the possibility under the circumstances, or is it to make it consistent with all other situations in law? And I mean, that's not a trick question. It's just what the intent is. I mean, is there a purpose behind what appears to be more limited circumstances where attorney's fees could be recovered in the civil action? Sure. If you could just tell us who you are and who you're with.
Absolutely. My name is Jonathan Crumley. I'm a civil attorney here in the state of Georgia, been practicing law for over 15 years in Georgia. I and Finn Little represent Susan Selmer in the civil suit. It was the companion civil suit arising out of the Final Exit Network case that resulted in this prior statute being overturned by the state Supreme Court. The thought process behind this section of the bill was essentially to provide a attorney's fees recovery provision that is fairly comparable to standard federal civil rights litigation, First Amendment, so any kind of federal civil rights claim. In that rubric or in that structure, a prevailing plaintiff is entitled to what's called a lodestar award, or the number of hours times the reasonable hourly rate for the area the case is pending, as a separate award over and above actual compensatory damages. By the same token, a losing plaintiff in a civil rights case is subject to potentially having to pay the state or municipality or federal government their legal expenses, but only upon showing that the case was essentially bad faith or frivolous. And so that is the reasoning behind the crafting of that structure. In many cases, and in fact you'll hear from Mrs. Selmer hopefully today, cases of this nature where you're dealing with end-of-care situations and there is an actual assisted suicide involved, on a wrongful death claim in the current state of Georgia, your potential recovery is going to be based on the full value of the life, but there's competing arguments and there's significant arguments to be made that the life has limited or minimal value, giving the amount of lifespan left for that particular person. So the reason for an attorney's fees clause would be to help provide for a mechanism where civil attorneys would actually want to pursue claims where there was an actual assisted suicide in the face of, ultimately, really on a typical plaintiff's case, a limited recovery just because of the typical fact situations.
Mr. Coomer.
Right, and I don't have any problem with that. I mean, I'd be fine with treble damages. I don't have a problem with that for the plaintiff side. My question is just to clarify the intent on the prevailing respondent side. Right. We're authorizing an award of attorney's fees. Do we want it to be for all of the potential reasons set forth in 9-15-14, or just for upon a showing that the action was frivolous? Because you know 9-15-14 has more than just frivolous. It has substantially frivolous, substantially groundless, substantially vexatious, imposed for delay or harassment, unnecessarily expanded the proceedings, and so on. So my question is, do you want the respondent who prevails to be limited to only recovering attorney's fees upon a showing that the action was frivolous, or upon a showing that any one of the 9-15-14 factors were met?
To Representative Coomer, we'd be open to a friendly amendment at the appropriate time.
Okay, to make it so that it would be it would apply, if any part of 915.14 applied, then that would...
To stop at frivolous, I mean, and again, if you think the entire sentence could be stricken, or?
Correct. Either stop or frivolous or strike the entire sentence to create the reason of the intent, I believe, was to have frivolous in there, so that's the sole grounds, because there's a whole body of case law defining what frivolous is. And again, that's the standard used in the federal civil rights structure. So there's that analogous body of law that could be drawn on by the courts. But there, as you know, from 915.14, there's multiple cases that address what would qualify as a frivolous claim in Georgia.
Just try the whole sentence. The statute's available.
I'd be comfortable with dropping the entire sentence.
Because as you pointed out earlier, even without frivolous, a defendant doesn't have to limit themselves to travel under this statute. They can read 915.14. They can assert abusive litigation tort under Title 51 if they follow the procedures. There's still the full panoply of defenses and claims available to defendants who believe they're being sued on a frivolous basis.
Okay. So at the appropriate time, then I'll make that motion.
Thank you.
I did have one other question, if I may.
Sure.
Getting back to the discussion earlier regarding advocacy, and this is going to display my ignorance of this particular topic, but is advocacy a term of art? Is that defined somewhere? Because as I read through this the first time, I'm scratching my head wondering what advocacy meant, and I heard it described adequately here. I understand what you mean by it. Is there something in the code or in case law that defines advocacy along those terms so that a court is not going to have to scratch its head and wonder what we meant?
There was thanks for the question. There was a proposal in subcommittee that specific professional advocates and ombudsmen be carved out from this. I was concerned to Representative Byrd's question that there may be family members who advocate on behalf of family members. We decided to leave it undefined and let the definition of advocacy speak for itself, because again, really the operative part of the statute is "but is not calculated or intended to cause the patient's death." We felt like those two working together were frankly adequate. I believe it's best not to define it, but again, as it pleases the committee, there may be another perspective.
Thank you.
Mr. Peck.
Thank you, Mr. Chairman. To follow up on Representative Coomer's question, it related to the attorney's fees provision. On line 48, it says the court may in its discretion, and I think you testify that you're trying to model after civil rights litigation. Am I correct about that?
Yes.
Is that mandatory? You get attorney's fees if you win?
It absolutely is.
So the question is, if you're trying to discourage people from engaging in this conduct, shouldn't it be a mandatory fee award instead of may? Because what I'm concerned about is the same kind of concern that I have with Representative Coomer. Is you're leaving the court without any standards as to when award of attorney's fees is appropriate and not. I'll leave it to the author on that, because it seems to me that you're kind of saying, okay, you could do it, but are they going to do it? Without any certainty, you're not going to provide any incentive for any plaintiff's attorneys to bring these cases.
To Representative Pack, I think, to your point, the court shall award reasonable attorney's fees, and if Representative Coomer, in his drafting his amendment, wouldn't want to include that, that would be a friendly amendment.
Any further questions for the author? Seeing none, thank you, Representative Setzler. Mr. Crumley, thank you also as well. Please hang around. Let me go ahead and call Mary Boyer with the Archdiocese of Atlanta.
And
I'm sorry, Mr. Setzler, did you have anything?
Mr. Chairman, I will say, and
I apologize.
Ms. Boyer may address this as well. I've got a handout that comes from the United States Conference of Catholic Bishops. I've put in your folder as well. Speaks to a 64-year-old retired school bus driver named Ms. Barbara Wagner. As you read through this, she had a cancer condition that in the Oregon State Health Plan, she got notification would not be covered, but the cost of assisted suicide would be covered. I'd like you to read this as we have time. One of the core purposes of this proposition is the notion of legalized assisted suicide is inseparable from the duty to die. And the idea of the right to die, that others should be able to help you kill yourself. I think we've seen in other countries, and we're seeing here is since 2008 and since then, those two concepts are frankly inseparable. And when a state health plan, as documented here, and we could provide any backup that you need, this is a nationally distributed pamphlet, again by what I think to be the very sober-minded Council for Catholic Bishops. If this isn't a wake-up call for us as a state, I'm not sure what is. So as you have time, I would encourage you to look at this resource. And, Mr. Chairman, I appreciate the opportunity to present the bill.
Thank you for bringing it to us. Just as a question, do you happen to recall how many states have an assisted suicide statute on the books as of now?
It's my understanding that currently 4 states have assisted suicide statutes legalizing physician-assisted suicide.
I meant a prohibition. I'm sorry.
It's 30, do you know the number?
30-something.
38, 39
High 30s.
states.
Okay. Good information.
And we currently do not.
Thank you, Representative Setzler. Ms. Boyer.
Thank you, Mr. Chairman and members of the committee, for the opportunity to speak on behalf of the Catholic Archdiocese of Atlanta. And basically, I represent the Respect Life Ministry, and the church's teaching on life basically extends from the beginning of life, which I mentioned to you last week when I was talking about the abortion bill, and of course the end of life. So we do support this bill, and we have been working with Representative Setzler, and we would like to see this bill passed. We feel that it would be a very bad precedent for the state of Georgia to allow no law on assisted suicide on our books. It would be sending a message that we allow assisted suicide in our state, and so we really applaud the committee for working through this very tough issue and feel that it's important to pass a good bill.
Thank you very much for your comments. I want to echo that and also say to Representative Setzler, I appreciate his responsiveness, especially in light of the timing of the Supreme Court ruling. It was pretty bang bang.
It was very quick.
To use the sports theme. Bang bang play. Thank you very much. I get that from Mr. Ramsey, by the way. Let me ask Dan Becker to come forward.
Thank you, Mr. Chairman, members of the committee. Dan Becker, President of Georgia Right to Life, and I do want to speak in regards to line 35. And I don't have the substitute, but I understand from its reading that the term is still present. Speaking of one of the phrases on line 35 that was actually used by Jack Kevorkian in 2 or 3 of his cases in Michigan where he was acquitted. And it was because largely of a phrase on line 35 that is the words hasten or. Those terms were used in his defense and were successful with the jury when a lethal dose was administered to the patient. He advocated successfully that all he was doing was alleviating pain. And because of the hastening of death, and because of that phrase in there, he was acquitted in those cases. We are concerned. I have just received notification from Burke Balch, who's the president of the Powell Center for Medical Ethics in Washington, D.C. That's National Right to Life's medical ethics arm. And he said that this bill is a good bill across the board with the exception of those 2 words, hasten or. Now, the federal law that bans funding for assisted suicide actually has struck those phrases from the federal law. In its place, it put the term for any reason.
at the conclusion of the federal law wording, for any reason, causing or the purpose of assisting in causing death for any reason. And so I would suggest to the committee that this is a concern of Georgia right to life, that at least minimally the term hasten or be struck from the bill as stated. And Mr. Chairman, just forgive me for the personal allusion, but tomorrow is the 6th anniversary of the passing of my wife with inflammatory breast cancer. Having walked through this from the standpoint of palliative care in the end-of-life stages, where we don't prolong the dying process, but we do, in fact, give medical treatment that alleviates pain as necessary. It's a fine line, and it's one that, having walked through it, it was very difficult to sign a do not resuscitate order, but at the same time realizing that the medical community is doing its best due diligence under the standard of care, and I believe that this bill addresses that concern from at least my personal experience and perspective. So I would ask that you consider striking at least those two words.
Mr. Sessler, do you want to address that? I don't want to put you on the spot. You don't. If you want to take some time, you can.
Thank you, Mr. Chairman. I didn't understand, and I know this probably came to Mr. Becker at the 11th hour. I recognize that. Just as I've tried to work with folks from the medical community, the hospice community, I'll be glad to, even during other testimony, to if there's a way that can substantively address the issue, I certainly want to give consideration to that. I'll say, I guess, parenthetically, that our challenge as we work through this was, and you're probably painfully aware of this, is that many procedures, what we would call legitimate procedures, for example, putting someone on morphine. I've just learned in the last week that putting someone on a morphine drip can be deemed to accelerate their death. Whereas perhaps they're on a glide path to die in 6 weeks, perhaps the morphine drip might have them, or if they're on a glide path to die in 7 days, maybe they'll die in 4 or 5 days under morphine. Perhaps that it allows the body to sort of slip into death in a more accelerated way. That's certainly not what we're looking to address. Our challenge is how can we get at the language, this all-important language, that a Kevorkian can't say, oh, I was just hastening their death. Perhaps they would have died in 6 weeks. I helped them die in 6 hours. We don't want that kind of thing. So I guess to your language, if I could see what you've got perhaps offline, I don't know how, unless you can phrase for us what you would propose, how that would get worked in.
It would be simply striking the word, and as I read Burke Balsh's statements, it was the experience of Jack Kevorkian being acquitted before juries in Michigan that led to the addition in the federal law of the phrase "for any reason" at the end of the excerpt from the federal law, and the federal's law reference only to increase the risk of death, not hasten. So the terminology "increase the risk of death" is acceptable. The hastening of death was the actual argument that was used by Kevorkian. So it would be to strike the term hasten or.
Mr. Chairman?
Sure.
Under the definition of, again, as we craft this, the elements of this that have to exist, there's a number of elements that have to exist here. Procedure such action. But is not calculated or intended to cause such patient's death.
And I apologize. This did arrive at the 11th hour.
We're wrestling with this.
Yeah.
Does the language "is not calculated or intended to cause a patient's death"? Is that not?
If a patient were already in the dying process and it was clear that medically they were not going to recover, then what I actually face personally was the decision to over-medicate my wife on morphine, more than even what she was self-administering to herself. And I was encouraged to do so. And that was a concern because of the hastening effect on damaging your organs by the morphine itself.
Mhm.
So, you know, there's latitude in the language that you have offered here. But that one phrase does, in fact, that was the essence of my concern 6 years ago, was the hastening, whether a willful act to actually hasten the death, because that is what an assisted suicide practitioner would, in fact, invoke as their defense. Because the person was dying anyway, all you're doing is hastening the dying process by alleviating pain in an overabundance.
Would you consider, or would Mr. Balch consider a helium bag over somebody's head where they die of helium asphyxiation in a matter of less than 20 minutes? I mean, to me, that's, one could argue that's hastening. I mean, we're all, one thing that's common to all of us is we're all going to die. Would that...
As the author knows, I'm not an attorney, so I'll leave it to you attorneys to address.
Well, let's do this. Let me recognize Representative Abrams for a question, and then if the author wants to think about that some more. It is a long process. We're not the last stop. We're just the first stop in this process, so we might afford ourselves the ability to use that time as the process goes on to take a harder look at it. Ms. Abrams.
Thank you, Mr. Chairman. I would ask for citations to the two laws that you're referencing. My concern is that that phrase, even though it is hasten or, and I think Chairman Setzler alluded to this, I'd like to understand those phrases in the context of the overall law, because my concern is that we would somehow try to strike language that actually may create a safe harbor when the overall bill itself may accomplish exactly what you seek to accomplish. So if you could provide us with those citations, I'd appreciate it.
Yes, thank you, Representative. It's the Assisted Suicide Funding Restriction Act 42, U.S. Code 14402, B4, paragraph B4.
And then the Michigan law, that, because I think the other issue is the Michigan law that use hasten or as an operative phrase, how it was used in their bill.
I do not have that.
Thank you.
Thank you, Mr. Chairman.
And thank you, Ms. Beck. If I may, I would just urge us to be cautious about changing the language on the fly, given that we're talking about two completely separate statutes that may or may not take into account how this has been framed.
Duly noted. Demetrius Mazakufo, representing the Georgia Hospice. I can't read the next word, Demetrius, I'm sorry.
Palliative care.
Palliative care.
Thank you, Mr. Chairman, members of the committee. Initially, we had serious concerns with the legislation as it was initially introduced, but now that we have been given a copy of the substitute, we feel much more comfortable and can say that it covers the concerns that we originally had. I have not seen the suggested substitute to subsection C, but if it comports with
Sorry.
But if it comports to parallel with just some clarification, then we will have no issues with the legislation. One of the things that we might want to suggest to the committee as it considers language that was raised by the previous speaker, the whole issue in hospice and in palliative care in general is not to hasten or increase the risk of death, but to alleviate the pain and suffering. And it may be appropriate if the committee wants to consider adding, in response to the previous speaker, adding the language that says with the intention on line 35, even if the medication, medical procedure, or advocacy has the intention to hasten or increase. That's a suggestion for this committee, but it's not something that we would have a position, but just a suggestion. Thank you.
Thank you, sir. Let me call on Melanie McNeil with the State Long-Term Care Ombudsman. Welcome.
Thank you, Mr. Chairman. Members of the committee, I'm Melanie McNeil. I'm the State Long-Term Care Ombudsman. We're advocates for long-term care residents. And the law that provides for long-term care ombudsman services is the Federal Older Americans Act, and there's also state law that provides for advocacy for residents. And we really appreciate Representative Seltzer's agreement to hear some of the concerns that we had, and that kind of address Representative Byrd's concerns. Ombudsman might advocate on behalf of a resident who, has a diagnosis of lung cancer. They're in a long-term care facility. They've smoked their whole life. This is the one thing that gives them comfort. The one thing they enjoy as they're nearing their end of life. So the concern was that the advocacy could be somehow interpreted then as a criminal act. So we really appreciate that Representative Seltzer was willing to make a change that would allow for advocacy for those kinds of things. Another thing that does come up and has come up on occasion since I've been ombudsman just for the last year and a half is the resident who says, I don't want to eat anymore. I'm really sort of at the end. It's not really a medical decision, but it's their decision about their life and want the ombudsman to be able to advocate on their behalf. They're not going to die like they would from a gunshot, but we know that if you don't eat, eventually you will die. So we just wanted to be sure that ombudsman could continue in their role, as they should, to advocate on behalf of what it is that the resident wants without being sort of caught up in this. So I think the adjustments that Representative Seltzer has made will make it possible for ombudsman to continue to fulfill their role without feeling like, oh my gosh, I might get arrested. So I appreciate that.
Thank you for your comments. Any questions? Seeing none. Thanks again. We recognize Susan Selmer. Ms. Selmer, would you like to come forward? We appreciate your taking the time to be here this afternoon.
Thank you for having me.
Absolutely.
Mr. Gold, if I could just briefly introduce
Sure.
Ms. Selmer, if it pleases the committee. As I alluded to earlier, Finn Little and I represent Ms. Selmer in her civil claim arising from the criminal final exit network case that just led to the reversal of the prior assisted suicide bill. One of the consequences of that decision is that, as I alluded to earlier, the level of damages available in many of these cases drops to next to nothing on the civil side, because when you evaluate the full value to life, you have to take into account the lifespan to be expected by the decedent. And in many cases, not necessarily Mr. Selmer's case, but in many cases, there's not a long lifespan expected. And so they can hide behind those, essentially commit these acts and not suffer any criminal or civil consequences, because there's not a significant amount of money at stake for the value of the life. To me, that's a travesty. Our state ought to be tilted in favor of life at all stages of life, and ought to be respected and honored. Briefly, before I turn it over to Ms. Selmer to let her describe what happened with her husband and with the Final Exit Network, the committee should know the Final Exit Network is a Georgia nonprofit corporation. They only moved their headquarters out of Georgia when these lawsuits got filed. The criminal sanctions out of Forsyth County, and then the follow-up civil case. That is an organization that used to use Georgia as its home base. It no longer does that, best we can tell. I've been provided some information. There's a doctor in Oregon by the name of Bill Toffler. He provided testimony to England when England's Parliament was taking up whether or not to allow assisted suicide in Great Britain or not. He's practiced in Oregon since the inception of Oregon's assisted suicide law, one of the most aggressive pro-death assisted suicide statutes in the country. His experience should be a clarion call to every medical professional in the state of Georgia. He describes a patient of his that came to him in 2005 with bladder cancer. And she said specifically, I'm concerned that my oncologist might be one of those death doctors that are not going to treat me properly to cure my cancer. That is the type of situation that will arise in the state of Georgia if we don't address this. Thankfully, Great Britain took his testimony to heart, and they voted to ban assisted suicide, to turn down the physician-assisted suicide bill by a vote of 148 to 100. This is an issue of life. This is one of the paramount issues that this body ought to be taking up as it does its business here. I'd like to turn it over to Ms. Selmer so she can explain to you exactly what happened, what these groups do to some of the most vulnerable people in our state.
Ms. Selmer, we welcome you. Let me just make sure it's clear. You're not under any duty to get into any details that are going to make you uncomfortable. I will tell you that we are very familiar with some of the details, the details in general of how this situation occurs. We don't want to make you uncomfortable at all. I want to make sure that you are, and so don't feel as if you have to get into something that's going to go ahead and make you upset. We don't want that. That's not going to be productive for anyone. But by the same token, if you have something that you feel strongly about that you'd like to tell us about, we're certainly here to listen, and we know that it takes a lot of strength and courage just to be sitting where you are right now under the circumstance. So I'll just leave it to you and whatever you're comfortable with.
Thank you.
Yes, ma'am.
I think one of the biggest things that you're dealing with the law and you're trying to cover all ends and protect people who legitimately give care to end-of-life patients, but the circumstances for me are such that it wasn't an end-of-life circumstance at all. And I feel like John's life was not given protection under the law in Georgia that I believe mandates suicide protection.
Take your time. No, take your time.
Prevention. And I feel like this organization, because of the fact that there is insufficient law to stop them, I'm not sure that the public knows the extent to which their actions go. John was 58 years old. He had been a cancer patient. Perhaps you could call him a cancer patient at the time of his death, even though there were no signs of cancer in the last couple of PET scans that he had had. He had undergone a 12-and-a-half-hour procedure to repair his jawbone that was damaged by the radiation. And he was still not recovered from that when they came in. So I would ask, whose agenda are they promoting when you are willing to not contact the family, when you will take a person who is desperate, that has gone through a great deal of physical pain, who lived for well over a year and a half after the initial surgery to remove the cancer in this portion of his jaw, who lived with a severed jawbone for 6 months, who had a hole the size of a quarter here from the damage from the radiation. And when he brushed what remained of his teeth, he could see the sink, and who worked day in and day out until the point where he could no longer. And they were reluctant to do the surgery initially because he was having continuous infections and had a hip that needed to be replaced, and those doctors would not treat him under the circumstances of the condition of the jaw. However, when you if you look into the surgery, while it's extremely extensive, basically what they do is they remove the jawbone, and they take approximately 12 inches of the bone out of the leg, and they shape and mold it and replace it in the jaw. And they use some titanium plates, and they take tissue from the leg and tissue transplants, and in his case they took his shoulder and half of his chest and brought it up over his neck. And left the tissue there, and he came home from the hospital while that tissue was still connected, which was very devastating for him. And he was had to continuously use suction because he couldn't swallow and he couldn't talk well. But that was, they then cut the flap and laid it down, but his chest was still raw and that tissue had not grown back yet, and he was not seeing beyond that. He was looking at the circumstances of the moment. And I think 99% of the psychological community would back me in saying that people who attempt suicide are in a desperate situation. They're in a situation where their pain far exceeds what they see as their ability or resources for being able to deal with that. And there are statistics that I don't have at hand that state that 90-some% of the people who attempt suicide and live are glad that they lived. John was not given that opportunity, and his death was unnecessary, because if I would ask you to go online and look at the surgery, and you see a man who was cut here and here, who was able to regain his speech and did not look, the aftermath of the surgery did not leave him in a manner in which you could not walk out in public. And even if it did, how have we given people the right to make that determination on somebody else's life? Because while John may have been desperate and depressed and he had been for over a year on morphine patches, oxycodone, and on and off of Chantix, how can anyone with any kind of real judgment determine that a person under those circumstances, and only days post-op, be in a position to make that decision? And if you think you are, the insufficiency of the law allows them to do that. And they preach about dignity, death with dignity. I want to ask you how one thinks that putting a bag over your head and tying it tight and putting a helium tube and sucking on helium until you die is dignified. And why are we allowing people to say that that is more dignified than going through a normal natural death process? And that doesn't occur. Death does not necessarily occur under those circumstances unless somebody is hands-on, because the natural instinct is to fight to pull the hood. So your hands have got to be held down. So even with sufficient intent, there's intent, they're off scot-free. And John is not the only case. In a matter of just 2 years after his death, there was evidence that there were at least well over 500 people. And it's not people at end of life. It's not people who just feel they can't live through the process of getting through whatever they are at the moment. It's people of all ages. I was told by a federal court in California that the literature in the hoods are being sold to children as young as 15 years old. The suicide rate for teenagers is on the rise in this country. Those children have lives ahead of them, and we're not protecting them because we're not offering them something better. John could have been living a productive life right now, and his life was snuffed out. The fact that and we talk mostly here about the medical community and risking giving people pain medication that might hasten their death. But to sneak into somebody's house when their family's not there, and there's a life, when you leave, there is no life, and you take the equipment with you, and you destroy the evidence, and then you go have dinner and celebrate. How do families deal with that? And then when you find the evidence and you discover that, how do you deal with that when the law doesn't protect you either? And I will tell you that it will be 4 years in June, and my life has been shattered. You can't probate a will because there's a federal investigation going on, and you can't get a death certificate, and I can't protect bank accounts, and there's 2 houses, and I can't sell a house. I can't get anybody to help me with another mortgage because because you can't get the documentation that you need to even proceed on that, and the fear. I mean, they knew where I lived. They knew what my cell phone number was. People who indiscriminately, they did not know his circumstances. They were not in a position to make that decision. Yet our law allows them to do that. They indiscriminately take people's lives. What would stop them from taking mine? I mean, I know that's not what we're here to discuss, but it created a great deal of fear for me. And you don't progress in a grieving process. And half the family knows, some of the family doesn't know. It creates all of those problems. And I think about all of the families out there we're talking about vulnerable people here. We're not just talking about what kind of treatment can we give to somebody who is dying. We're talking about why aren't we helping the people that are living that need help? And why instead are we allowing people to just, as I said, indiscriminately take lives and pay no penalty?
We appreciate your coming down here this afternoon. Thank you.
Thank you for hearing me.
I know it took a lot, so thank you. We'll get it done. We will get it done. I think what we'll do is we will hold the bill for a day. We will have a special meeting set. We have a long calendar tomorrow, but I don't get the sense it'll go long time-wise. So I think what we'll do is we'll set a special meeting for tomorrow, depending on when I can get a room, at what hour. I'm going to shoot for 1 o'clock, 1:30 upon adjournment, essentially. And I think what we'll do is, and this is in consultation with the author, to go ahead and take a look at some language. Take an extra day. It's always a good idea. And then we'll just, as soon as we get to a quorum, the author can go ahead and talk to any substitute that he may have at that time. That'll incorporate the additional language that he showed us today, and then we'll just get right to a motion. Is that an accurate reflection, Mr. Setzler? Okay. And with that, we'll be adjourned. Thank you all.